Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. Har Har Mahadev Jai Shiv Shambhu. In today's class, we will discuss about Section 17A of Prevention of Corruption Act. But topic is too much technical. It is not easier to discuss everything in short. But as I told you, the concerned topic is technical in nature. So if I will discuss a topic as a lawyer, in that scenario, you would not be acquainted with the subject. So I will discuss the subject in the easier way so that you could consider the subject and could be acquainted with the legal provisions so that you are having any trouble. You could easily encounter the same without getting any panic or anxiety. I request all of you to maintain the proper notebook with pen or pencil and please pinpoint on the subject. So, first of all, we will discuss the fundamentals about Section 17A of PC Act. Basically, the protocol is inserted to protect the public servant from false litigations under the PC Act. It was not in the PC Act at the inception, but later on, by the virtue of amendment, it is inserted. So, two points are quite clear to us. Section 17A is inserted to provide protection to public servant from the false litigations under the PC Act, and inter alia, it is inserted in the year of 2018. So, basically, it mandates that the officer of police. Basically, the case under PC Act is inter alia booked by ACB or by vigilance or by CBI. So we may replace the word police officer with CBI, vigilance or with ACB. So simply it mandates that the officer of CBI or vigilance or ACB must obtain the prior approval from the competent government. You got my point now? Or from the competent authority before conducting any inquiry or investigation into the alleged offence under the PC Act, alleged to be committed by the public servant. So basically, by the bare perusal of fundamental, it is quite clear to us that if any offence is committed by public servant, then before doing any inquiry or investigation in that offence, the prior approval is must. Without the prior approval, the proceedings could not be conducted in nature of inquiry or investigation. But the fundamental is not sufficient to give the specific idea about the protocol of section 17A of PCA. So basically, we have to consider the key points. Point number one, the prior approval is mandatory concerning the offences under the PC Act, and the offence must relate to the recommendation or decision made by public servant in the official capacity. Number two, the approval is required to become either from the union government or from the state government or from the authority competent to remove the public servant from the office. It depends upon the individual employment. But there is an exception to the said protocol. It says that where the accused person is caught red-handed and he is trapped and arrested on the spot, in that scenario, the benefit of Section 17A of PCA could not be given. Recently, Honorable Rajasthan High Court, in its judgment, Rani Dhan versus State of Rajasthan, judgment date is 8th of October 2024, had quashed the proceeding against public servant due to non-compliance of Section 17A of PCA. In that case, the concerned officials of police were public servant and they were charged for demand only. And inter alia, FIR is registered and finally the proceedings are conducted. The court quashed the entire proceeding on ground that there is no compliance of Section 17 of PCA. So if there is any nexus regarding the work and regarding the alleged demand, and the accused is not caught red-handed, in that scenario, Section 17 of PCA is mandatory. If there is no due compliance in that scenario, the benefit could be inclined to the accused and the proceedings being abuse of process are liable to be quashed and set aside. Apart from that, the authority to whom the submissions are made is required to decide the approvals within 3 months, and apart from that, the extension of 1 month could be given. But before passing any adverse order, the authorities are required to hear the concerned opposite party, means the public servant. If the order is in affirmative, means approval is given, but opportunity of being heard is not given to you, you may challenge the proceeding on ground that there is violation of principle of natural justice. You got my point now? In addition to this, we are having judgment of Honorable Supreme Court, Honorable Delhi High Court, Honorable Rajasthan High Court, wherein it is specified that if there is no compliance of Section 17 of PC8, entire proceedings are liable to be quashed and set aside. In addition to this, regarding the uniform execution of Section 17 of PC8, the government had issued SOP, which means Standard Operating Procedure. Basically, the consent protocol is required to be followed. If the protocol is not followed, in that scenario, the proceeding will be void ab initio. So basically, if you're not getting any benefit of Section 17A of PC8 and the proceedings are going to be conducted in the illegal manner, the submission is required to be given to the concerned IO to do compliance of Section 17 of PC8. But in case he deliberately failed to do so, in that scenario, we may approach to Honorable High Court as per Section 528 of BNSS, because the said protocol deal with the inherent power of the Honorable High Court, and if there is any abuse of proceeding, Honorable High Court could intervene. So basically, you are a public servant. The case is of demand only, and there is no evidence regarding recovery, acceptance, arrest on spot. In that scenario, you deserve the benefit of Section 17 of PCA. So if the benefit is not given, to avail the benefit and to quash the proceeding, you may approach as per Section 528 of BNSS, as I told you, so that remedy could be inclined and the proceedings, which are totally fictitious, totally absurd, could be set aside and quashed. So I think that I enlightened you on the subject. See you in the next video. Till then, Jai Hind, Jai Bharat.